Truth in Lending Act tone. The Truth in Lending Act TILA, 15 U.S.C. 1601 its Sec. was enacted on May 29, 1968, as Title I of the Consumer Credit Protection Act, Pub L 90-321. 90-321. The TILA, implemented by Regulation Z 12 CFR 1026, became effective July 1, 1969. The TILA was first amended in 1970 to prohibit unsolicited credit cards. Additional major amendments to the TILA and Regulation Z were made by the Fair Credit Billing Act of 1974, the Consumer Leasing Act of 1976, the Truth in Lending Simplification and Reform Act of 1980, the Fair Credit and Charge Card Disclosure Act of 1988, the Home Equity Loan Consumer Protection Act of 1988. Regulation Z also was amended to implement Section 1204 of the Competitive Equality Banking Act of 1987, and in 1988, to include adjustable rate mortgage loan disclosure requirements. All consumer leasing provisions were deleted from Regulation Z in 1981 and transferred to Regulation M12 CFR 1013. The Homeownership and Equity Protection Act of 1994, HOPA, amended the TILA. The law imposed new disclosure requirements and substantive limitations on certain closed-end mortgage loans bearing rates or fees above a certain percentage or amount. The law also included new disclosure requirements to assist consumers in comparing the costs and other material considerations involved in a reverse mortgage transaction and authorized the Federal Reserve Board to prohibit specific acts and practices in connection with mortgage transactions. The TILA amendments of 1995 dealt primarily with tolerances for real estate secured credit. Regulation Z was amended on September 14, 1996 to incorporate changes to the TILA. Specifically, the revisions limit lenders' liability for disclosure errors in real estate secured loans consummated after September 30, 1995. The Economic Growth and Regulatory Paper Reduction Act of 1996 further amended the TILA. The amendments were made to simplify and improve disclosures related to credit transactions. The Electronic Signatures in Global and National Commerce Act, the e-Sign Act, 15 U.S.C. 7001 et Sec. was enacted in 2000s, not require implementing regulations. On November 9, 2007, amendments to Regulation Z and the official commentary were issued to simplify the regulation and provide guidance on the electronic delivery of disclosures consistent with the e-Sign Act. In July 2008, Regulation Z was amended to protect consumers in the mortgage market from unfair, abusive, or deceptive lending and servicing practices. Specifically, the change applied protections to a newly defined category of higher-priced mortgage loans that includes virtually all closed-end subprime loans secured by a consumer's principal dwelling. The revisions also applied protections to mortgage loans secured by a dwelling, regardless of loan price, and required the delivery of early disclosures for more types of transactions. The revisions also: 1. These reflect FIC-approved procedures. CFPB, April 2015, TILA 1. CFPB, Laws and Regulations TILA. Banned several advertising practices deemed deceptive or misleading. The Mortgage Disclosure Improvement Act of 2008 MDIA broadened and added to the requirements of the board's July 2008 final rule by requiring early truth in lending disclosures for more types of transactions, and by adding a waiting period between the time when disclosures are given and consummation of the transaction. In 2009, Regulation Z was amended to address those provisions. The MDIA also requires disclosure of payment examples if the loan's interest rate or payments can change, as well as disclosure of a statement that there is no guarantee the consumer will be able to refinance in the future. In 2010, Regulation Z was amended to address these provisions, which became effective on January 30, 2011. In December 2008, the board adopted 2 final rules pertaining to open-end, not home-secured credit. The first rule involved Regulation Z revisions and made comprehensive changes applicable to several disclosures required for applications and solicitations, new account periodic statements, change in terms notifications, and advertisements. The second was a rule published under the Federal Trade Commission (FTC) Act and was issued jointly with the Office of Thrift Supervision and the National Credit Union Administration. It sought to protect consumers from unfair acts or practices with respect to consumer credit card accounts. Before these rules became effective, however, the Credit Card Accountability, Responsibility and Disclosure Act of 2009 Credit Card Act amended the TILA and established a number of new requirements for open and consumer credit plans. Several provisions of the Credit Card Act are similar to provisions in the board's December 2008 TILA revisions and the joint FTC Act rule. But other portions of the Credit Card Act address practices or mandate disclosures that were not addressed in these rules. In light of the Credit Card Act, the board, NCUA, and OTS withdrew the substantive requirements of the joint FTC Act rule. On July 1, 2010, compliance with the provisions of the board's rule that were not impacted by the Credit Card Act became effective. The Credit Act provisions became effective in 3 stages. The provisions effective 1 August 20, 2009, required creditors to increase the amount of notice consumers receive before the rate on a credit card account is increased or a significant change is made to the account's terms. These amendments also allowed consumers to reject such increases and changes by informing the creditor before the increase or change goes into effect. The provisions effective next February 22, 2010 involved rules regarding interest rate increases, over-the-limit transactions, and student cards. Finally, the provisions effective last August 22, 2010, addressed the reasonableness and proportionality of penalty fees and charges and re-evaluation of rate increases. In 2009, Regulation was amended following the passage of the Higher Education Opportunity Act, HEOA, by adding disclosure and timing requirements that apply to lenders making private education loans. In 2009, the Helping Families Save Their Homes Act amended the TILA to establish a new requirement for notifying consumers of the sale or transfer of their mortgage loans. The purchaser or assignee that acquires the loan must provide the required disclosures no later than 30 days after the date on which it acquired the loan. In 2010, the board further amended Regulation Z to prohibit payment to a loan originator that is based on the terms or conditions of the loan, other than the amount of credit extended. The CFPB, April 2015, TILA 2. CFPB. Laws and Regulations TILA. Amendment applies to mortgage brokers and the companies that employ them, as well as to mortgage loan officers employed by depository institutions and other lenders. In addition, the amendment prohibits a loan originator from acting or steering a consumer to a loan that is not in the consumer's interest to increase the loan originator's compensation. The Dodd-Frank Wall Street Reform and Consumer Protection Act of 2010 Dodd-Frank Act amended the TILA to include several provisions that protect the integrity of the appraisal process when a consumer's home is securing the loan. The rule also requires that appraisers receive custody and reasonable payments for their services. The appraiser and loan originator compensation requirements had a mandatory compliance date of April 6, 2011. The Dodd-Frank Act generally granted rulemaking authority under the TILA to the Consumer Financial Protection Bureau, CFPB. Title of the Dodd-Frank Act included a number of amendments to the TILA, and in 2013, the CFPB issued rules to implement them. Prohibitions on mandatory arbitration and waivers of consumer rights, as well as requirements that lengthen the time creditors must maintain an escrow account for higher-priced mortgage loans, were generally effective June 1, 2013. The remaining amendments to Regulation Z were effective in January 2014. Two of these amendments include ability to repay requirements for mortgage loans, appraisal requirements for higher-priced mortgage loans, a revised and expanded test for high-cost mortgages, as well as additional restrictions on those loans, expanded requirements for servicers of mortgage loans, refined loan originator compensation rules and loan origination qualification standards, and a prohibition on financing credit insurance for mortgage loans. The amendments also established new record retention requirements for certain provisions of the TILA. On October 22, 2014, the CFPB issued a final rule providing an alternative small servicer definition for nonprofit entities and amended ability to repay exemption for nonprofit entities. The final rule also provided a cure mechanism for the points and fees limit that applies to qualified mortgages. The rule was effective on November 3, 2014, except for one provision that will be effective on August 1, 2015. In 2015, the CFPB also revised several open-end credit provisions in Regulation Z. The CFPB revised the general limitation on the total amount of account fees that a credit card issuer may require a consumer to pay. Effective March 28, 2013, the limit is 25% of the credit limit in effect when the account is opened and applies only during the first year after account opening. The CFPB also amended Regulation Z to remove the requirement that card issuers consider the consumer's independent ability to pay for applicants who are 21 or older, and to permit issuers to consider income and assets to which such consumers have a reasonable expectation of access. This change was effective May 3, 2013, with a mandatory compliance date of November 4, 2013. In 2013, the CFPB further amended Regulation Z as well as Regulation X, the regulation implementing the Real Estate Settlement Procedures Act (RESPA), to fulfill the mandate in the 2. The amendment to 12 CFR 1026.35e was effective July 24, 2013. The amendments to Section 12 CFR 1026.35b2 do evade the 26.3. The amendment to Section 12 CF 24. The amendments and F in Sup I to Part 1026 were effective January 1, 2018. These FFIEC examination procedures cover amendments to Regulation Z that were issued by the CFPB in final form as of January 20, 2015. CFPB, April 2015 TILA 3. CFPB, Laws and Regulations TILA. Dodd-Frank Act to integrate the mortgage disclosures under TILA and RESPA Sections 4 and 5. Regulation Z now contains 2 new forms required for most closed-end consumer mortgage loans. The loan estimate is provided within 3 business days from application, and the closing disclosure is provided to consumers 3 business days before loan consummation. These disclosures must be used for mortgage loans for which the creditor or mortgage broker receives an application on or after August 1, 2015. Format of Regulation Z. The rules creditors must follow differ depending on whether the creditor is offering open-end credit, such as credit cards or home equity lines, or closed-end credit, such as car loans or mortgages. Subpart A, Sections 1026.1 through 1026.4 of the regulation provides general information that applies to open-end and closed-end credit transactions. It sets forth definitions 1026.2 and stipulates which transactions are covered and which are exempt from the regulation 1026.3. It also contains the rules for determining which fees are finance charges 1026.4. Subpart B, Sections 1026.5 through 1026.16 relates to open-end credit. It contains rules on account opening disclosures 1026.6 and periodic statements 1026.7 to 8. It also describes special rules that apply to credit card transactions, treatment of payments 1026.10. Credit balances 1026.11, procedures for resolving credit billing errors 1026.13, annual percentage rate calculations 1026.14, rescission rights 1026.15, and advertising 1026.16. Subpart C, Sections 1026.1, 7 through 1026.24, relates to closed-end credit. It contains rules on disclosures 1026.1, 7 to 20, treatment of credit balances 1020.21, annual percentage rate calculations 1026.22, rescission right 1026.23, and advertising 1026.24. Sub D, Sections 1026.25 through 1026.30. Contain rules on oral disclosures 1026.26. Disclosures in languages other than 1026.27. Record retention 1026.25. Effect on state laws 1026.28. State exemptions 1026.29. and rate limitations 1026.30. Subpart E, Sections 1020 inspections. The rules require certain disclosures and provide limitations for closed-end credit transactions and open-end credit plans that have rate fees above specified amounts or certain prepayment penalties. 1026.32. Special disclosures are also required, including the total annual loan cost rate. For reverse mortgage transactions, 1026.33. The rules also prohibit specific acts and practices in connection with high-cost mortgages, as defined in 12 CFR 1026.32a, 1026.34, in connection with closed-end higher-priced mortgage loans, as defined in 12 CFR. There are additional regulations that take effect on August 1, 2015, regardless of whether an application has been received on that date. Specifically, the rule restricts the imposition of fees on a consumer before the consumer has received the loan estimate and indicated an intent to proceed. Providing a consumer with a written estimate of terms or costs prior to providing the loan estimate, without also providing a written statement informing the consumer that the terms or costs may change. The rule also restricts a creditor from requiring the submission of documents verifying information related to the consumer's application before providing the loan estimate. CFPB, April 2015, TILA 4. CFPB, Laws and Regulations TILA. 1026.35a, 1026.35, and in connection with an extension of credit secured by a dwelling, 1026.36i. Disclosure requirements, effective August 1, 2015, for most closed-end transactions secured by real property, as required by 12 CFR 1026.19e and f, are also provided 1026.37 to 38. Subpart F, Sections 1026.46 through 1026.48, relates to private education loans. It contains rules on disclosures, 1026.46, limitations on changes in terms after approval, 1026.48, the right to cancel the loan, 1026.47, and limitations on CO branding in the marketing of private education loans, 1026.48. Subpart G, Sections 1026.51 through 1026.60, relates to credit card accounts under an open-end, not home-secured consumer credit plan, except for 1026.5, Sep C, which applies to all open-end credit plans. This subpart contains rules regarding credit and charge card application and solicitation disclosures, 1026.60. It also contains rules on evaluation of a consumer's ability to make the required payments under the terms of an account 1026.51, limits the fees that a consumer can be required to pay 1026.52, and contains rules on allocation of payments in excess of the minimum payment 1026.53. It also sets forth certain limitations on the imposition of finance charges as the result of a loss of a grace period 1026.54 and on increases in annual percentage rates fees and charges for credit card accounts 1026.55, including the reevaluation of rate increases 1026.59. This prohibits the assessment of fees or charges for over-the-limit transactions unless the consumer affirmatively consents to the creditor's payment of over-the-limit transactions, 1026.56. This subpart also sets forth rules for reporting and marketing of college student open-end credit, 1026.51. Finally, it sets forth requirements for the internet posting of credit card accounts under an open-end, not home-secured consumer credit plan, 1026.58. Several appendices contain information such as the procedures for determinations about state laws, state exemptions and issuance of official interpretations, special rules for certain kinds of credit plans, model disclosure forms, standards for determining ability to pay, and the rules for computing annual percentage rates in closed-end credit transactions and total annual loan cost rates for reverse mortgage transactions. Official interpretations of the regulation are published in a commentary, Good faith compliance with the commentary protects creditors from liability under the TILA. In addition, the commentary includes more detailed information on disclosures or other actions required of creditors. It is virtually impossible to comply with Regulation Z without reference to and reliance on the commentary. Note: the following narrative does not discuss all the sections of Regulation Z, but rather highlights only certain sections of the regulation and the TILA. CFPB, April 2015, TILA 5. CFPB, Laws and Regulations, TILA. Subpart A, General. This subpart contains general information regarding both open-end and closed-end credit transactions. It sets forth definitions 1026.2 and sets out which transactions are covered and which are exempt from the regulation 1026.3. It also contains the rules for determining which fees are finance charges 1026.4. Purpose of the TILA and Regulation Z. The TILA is intended to ensure that credit terms are disclosed in a meaningful way, so consumers can compare credit terms more readily and knowledgeably. Before its enactment, consumers were faced with a bewildering array of credit terms and rates. It was difficult to compare loans because they were seldom presented in the same format. Now, all creditors must use the same credit terminology and expressions of rates. In addition to providing a uniform for disclosures, the Act protects consumers against inaccurate and unfair credit billing and credit card practices, provides consumers with rescission rights, provides for rate caps on certain dwelling-secured loans, imposes limitations on home equity lines of credit and certain closed-end home mortgages, provides minimum standards for most dwelling-secured loans, and delineates and prohibits unfair or deceptive mortgage lending practices. The TILA and Regulation Z do not, however, tell financial institutions how much interest they may charge or whether they must grant a consumer a loan. Summary of coverage considerations, Sections 1026.1 and 1026.2. Lenders must carefully consider several factors when deciding whether a loan requires truth in lending disclosures or is subject to other Regulation Z requirements. The coverage considerations under Regulation Z are addressed in more detail in the commentary to Regulation Z. For example, broad coverage considerations are included under Section 1026.1c of the regulation, and relevant definitions appear in Section 1026.2. Exempt transactions, Section 1026.3. The following transactions are exempt from Regulation Z. Credit extended primarily for a business, commercial, or agricultural purpose. CFPB, April 2015, TILA 6. CFPB, Laws and Regulations, TILA. Credit extended to other than a natural person, including credit to government agencies or instrumentalities. Credit in excess of an annually adjusted threshold not secured by real property or by personal property used or expected to be used as the principal dwelling of the consumer. Public utility credit. Credit extended by a broker-dealer registered with the Securities and Exchange Commission, SEC, or the Commodity Futures Trading Commission, CFTC, involving securities or commodities accounts. Home fuel budget plans not subject to a finance charge, and certain student loan programs. However, when a credit card is involved, generally exempt credit, e.g., business purpose credit, is subject to the requirements that govern the issuance of credit cards and liability for their unauthorized use. Credit cards must not be issued on an unsolicited basis, and, if a credit card is lost or stolen, the cardholder must not be held liable for more than $50 for the unauthorized use of the card. Comment 3-1. When determining whether credit is for consumer purposes, the creditor must evaluate all of the following. Any statement obtained from the consumer describing the purpose of the proceeds. For example, a statement that the proceeds will be used for a vacation trip would indicate a consumer purpose. If the loan has a mixed purpose, e.g., proceeds will be used to buy a car that will be used for personal and business purposes. The lender must look to the primary purpose of the loan to decide whether disclosures are necessary. A statement of purpose from the consumer will help the lender make that decision. A checked box indicating that the loan is for a business purpose, absent any documentation showing the intended use of the proceeds, could be insufficient evidence that the loan did not have a consumer purpose. The consumer's primary occupation and how it relates to the use of the proceeds. the higher the correlation between the consumer's occupation and the property purchased from the loan proceeds, the greater the likelihood that the loan has a business purpose. For example, proceeds used to purchase dental supplies for a dentist would indicate a business purpose. The Dodd-Frank Act requires that this threshold be adjusted annually by any annual percentage increase in the Consumer Price Index for urban wage earners and clerical workers, CPIW. Based on the annual percentage increase in the CPIW as of June 1, 2012, the exemption threshold increased from $51,800 to $53,000, effective January 1, 2013. CFPB, April 2015. 7. CFPB. Laws and Regulations. TILA. Personal management of the assets purchased from proceeds. The lower the degree of the borrower's personal involvement in the management of the investment or enterprise purchased by the loan proceeds, the less likely the loan will have a business purpose. For example, money borrowed to purchase stock in an automobile company by an individual who does not work for that company would indicate a personal investment and a consumer purpose. The size of the transaction. The larger the size of the transaction, the more likely the loan will have a business purpose. For example, if the loan is for a $5 million real estate transaction, that might indicate business purpose. The amount of income derived from the property acquired by the loan proceeds relative to the borrower's total income. The lesser the income derived from the acquired property, the more likely the loan will have a consumer purpose. For example, if the borrower has an annual salary of $100,000 and receives about $500 in annual dividends from the acquired property, that would indicate a consumer purpose. All 5 factors must be evaluated before the lender can conclude that disclosures are not necessary. Normally, no one factor by itself is sufficient reason to determine the applicability of Regulation Z. In any event, the financial institution may routinely furnish disclosures to the consumer. Disclosure under such circumstances does not control whether the transaction is covered, but can assure protection to the financial institution and compliance with the law. CFPB, April 2015. TILA 8. CFPB. Laws and Regulations. Coverage considerations under Regulation Z. TILA is the purpose of the credit for personal, family, or household use. No Regulation Z does not apply except for the rules of issuance of an unauthorized use liability for credit cards. Exempt credit includes loans with a business or agricultural purpose and certain student loans. Credit extended to acquire or improve rental property that is not owner-occupied is considered business purpose credit. Yes. Is the consumer credit extended to a consumer? No, Regulation Z does not apply. Credit that is extended to a land trust is deemed to be credit extended to a consumer. Yes, the institution is not a creditor, and Regulation Z does not apply unless at least one of the following tests is met. 1. The institution extends consumer credit regularly, and is the consumer credit extended by a creditor? No. The obligation is initially payable to the institution, and the obligation is either payable by written agreement in more than 4 installments or is subject to a finance charge. 2. The institution is a card issuer that extends closed-end credit that is subject to a finance charge or is payable by written agreement in more than 4 installments. The institution is not the card issuer, but it imposes a finance charge at the time of honoring a credit card. Yes. Is the loan or credit plan secured by real property or by a dwelling? No. Is the amount financed or credit limit $50,000 or less? No. Regulation Z does not apply, but may apply later if the loan is refinanced for $53,000 or less. If the principal dwelling is taken as collateral after consummation, rescission rights will apply, and in the case of open-end credit, billing disclosures and other provisions of Regulation Z will apply. Yes. Regulation Z applies. CFPB, April 2015. TILA 9. CFPB. Laws and Regulations. TILA. Determination of finance charge and annual percentage rate, APR. Finance charge, open-end and closed-end credit. Section 1026.4. The finance charge is a measure of the cost of consumer credit represented in dollars and cents. Along with APR disclosures, The disclosure of the finance charge is central to the uniform credit cost disclosure envisioned by the TILA. The finance charge does not include any charge of a type payable in a comparable cash transaction. Examples of charges payable in a comparable cash transaction may include taxes, title, license fees, or registration fees paid in connection with an automobile purchase. Finance charges include any charges or fees payable directly or indirectly by the consumer, and imposed directly or indirectly by the financial institution, either as an incident to or as a condition of an extension of consumer credit. The finance charge on a loan always includes any interest charges and often other charges. Regulation Z includes examples applicable both to open-end and closed-end credit transactions of what must not, or need not be included in the disclosed finance charge 1026.4b. Accuracy tolerances, closed-end credit, sections 1026.18d and 1026.23g. Regulation Z provides finance charge tolerances for legal accuracy that should not be confused with those provided in the TILA for reimbursement under regulatory agency orders. As with those APRs, if a disclosed finance charge were legally accurate, it would not be subject to reimbursement. Under the TILA and Regulation Z, finance charge disclosures for open-end credit must be accurate, since there is no tolerance for finance charge errors. However, both the TILA and Regulation Z permit various finance charge accuracy tolerances for closed-end credit. Tolerances for the finance charge in a closed-end transaction, other than a mortgage loan, are generally $5 if the amount financed is less than or equal to $1,000 and $10 if the amount financed exceeds $1,000. Tolerances for certain transactions consummated on or after September 30, 1995, are noted below. Credit secured by real property or a dwelling closed-end credit only. The disclosed finance charge is considered accurate if it is not understated by more than 100%. Overstatements are not violations. Rescission rights after the 3 business day rescission period, closed-end credit only. CFPB April 2015 TILA 10. CFPB. Laws and Regulations TILA. The disclosed finance charge is considered accurate if it does not vary from the actual finance charge by more than 0.5% of the credit extended or $100, whichever is greater. The disclosed finance charge is considered accurate if it does not vary from the actual finance charge by more than 1% of the credit extended for the initial and subsequent refinancings of residential mortgage transactions when the new loan is made at a different financial institution. This excludes high-cost mortgage loans subject to Section 1026.32, transactions in which there are new advances and new consolidations. Rescission rights and foreclosure. The disclosed finance charge is considered accurate if it does not vary from the actual finance charge by more than $35. Overstatements are not considered violations. The consumer can rescind if a mortgage broker fee that should have been included in the finance charge was not included. Note, normally the finance charge tolerance for a rescindable transaction is either 0.5% of the credit transaction or, for certain refinancings, 1% of the credit transaction. However, in the event of a foreclosure, the consumer may exercise the right of rescission if the disclosed finance charge is understated by more than $35. See the finance charge tolerances charts within these examination procedures for help in determining appropriate finance charge tolerances. Calculating the finance charge, closed-end credit. One of the more complex tasks under Regulation Z is determining whether a charge associated with an extension of credit must be included in, or excluded from, the disclosed finance charge. The finance charge initially includes any charge that is or will be connected with a specific loan. Charges imposed by third parties are finance charges if the financial institution requires the third party. Charges imposed by settlement or closing agents are finance charges if the bank requires the specific service that gave rise to the charge and the charge is not otherwise excluded. The finance charge tolerances charts within this document briefly summarize the rules that must be considered. Prepaid finance charges, Section 1026.18b3. A prepaid finance charge is any finance charge paid separately to the financial institution or to a third party in cash or by check before or at closing, settlement, or consummation of a transaction, or withheld from the proceeds of the credit at any time. Prepayment charges effectively reduce the amount of funds available for the consumer's use, usually before or at the time the transaction is consummated. CFPB, April 2015, TILA 11. CFPB. Laws and Regulations, TILA. Examples of finance charges frequently prepaid by consumers are borrower's points, loan origination fees, real estate construction inspection fees. Odd days interest attributable to part of the first payment period, when that period is longer than a regular payment period. Mortgage guarantee insurance fees paid to the Federal Housing Administration. Private mortgage insurance PMI, paid to such companies as the Mortgage Guarantee Insurance Company MGIC, and, in non-real estate transactions, credit report fees. Pre-computed finance charges. A pre-computed finance charge includes, for example, interest added to the note amount that is computed by the add-on, discount, or simple interest methods. If reflected in the face amount of the debt instrument as part of the consumer's obligation, finance charges that are not viewed as prepaid finance charges are treated as pre-computed finance charges that are earned over the life of the loan. CFPB, April 2015, TILA 12. CFPB. Laws and Regulations, TILA. Finance charge chart. Finance charge equal to dollar cost of consumer credit. It includes any charge payable directly or indirectly by the consumer and imposed directly or indirectly by the creditor as a condition of or incident to the extension of credit. Charges always included interest, transaction fees, loan origination fees, consumer points, credit guarantee insurance, premiums, charges imposed on the creditor for purchasing the loan, which are passed on to the consumer. Discounts for inducing payment by means other than credit. Mortgage broker fees. Other examples: fee for preparing TILA disclosures, real estate construction loan inspection fees, fees for post-consummation tax or flood service policy, required credit, life insurance charges included unless conditions are met, premiums for credit life A&H or loss of income insurance, debt cancellation fees, premiums for property or liability insurance, premiums for vendors' single interest VSI insurance, security interest charges, filing fees, insurance in lieu of filing fees, and certain notary fees, charges imposed by third parties, closing agents, appraised credit report fees, conditions any loan, insurance not required, disclosures are made and consumer authorizes, coverage not required, disclosures are made and consumer authorizes. Consumer selects insurance company and disclosures are made. Insurer waives right of subrogation, consumer selects insurance company and disclosures are made. The fee is for lien purposes prescribed by law, payable to a third public official and is itemized and disclosed. Use the third party is not required to obtain loan and creditor does not retain the charge. Creditor does not require and does not retain the fee for the particular service. Application fees, if charged to all applicants, are not finance charges. Application fees may include appraisal or credit report fees. Charges not included if bona fide and reasonable in amount residential mortgage transactions and loans secured by real estate. Fees for title insurance, title examination, property search, etc. Fees for preparing loan documents, mortgages, and other settlement documents. Amounts required to be paid into escrow, if not otherwise included in the finance charge, notary fees, pre-consummation flood and pest inspection fees, appraisal and credit report fees, charges never included, charges payable in a comparable cash transaction, fees for unanticipated late payments, fees not agreed to in writing, seller's points, participation or membership fees, discount offered by the seller to induce payment by cash or other means not involving the use of a credit card, interest forfeited as a result of interest reduction required by law, charges absorbed by the creditor as a cost of doing business. CFP, April 2015, TILA 13. CFPB. Laws and Regulations, TILA. Instructions for the Finance Charge Chart. The The finance charge initially includes any charge that is or will be connected to a specific loan. Charges imposed by third parties are finance charges if the creditor requires use of the third party. Charges imposed on the consumer by a settlement agent are finance charges only if the creditor requires the particular services for which the settlement agent is charging the borrower, and the charge is not otherwise excluded from the finance charge. Immediately below the finance charge definition, the chart presents 5 captions applicable to determining whether a loan-related charge is a finance charge. The caption is "Charges always included." This category focuses on specific charges given in the regulation or commentary as examples of finance charges. The second caption, "Charges included unless conditions are met," focuses on charges that must be included in the finance charge unless the creditor meets specific disclosure or other conditions to exclude the charges from the finance charge. The third caption, "Conditions," focuses on the conditions that need to be met if the charges identified to the left of the conditions are permitted to be excluded from the finance charge. Although most charges under the second caption may be included in the finance charge at the creditor's option, third-party charges and application fees listed last under the third caption must be excluded from the finance charge if the relevant conditions are met. However, inclusion of appraisal and credit report charges as part of the application fee is optional. The fourth caption, "Charges not included," identifies fees or charges that are not included in the finance charge under conditions identified by the caption. If the credit transaction is secured by real property or the loan is a residential mortgage transaction, the charges identified in the column, if they are bona fide and reasonable in amount, must be excluded from the finance charge. For example, if a consumer loan is secured by a vacant lot or commercial real estate, any appraisal fees connected with the loan must not be included in the finance charge. The fifth caption, "Charges never included," lists specific charges provided by the regulation as examples of those that automatically are not finance charges, e.g., fees for unanticipated late payments. Annual percentage rate definition, Section 1026.2, Closed-end credit. Credit costs may vary depending on the interest rate, the amount of the loan and other charges, the timing and amounts of advances, and the repayment schedule. The APR, which must be disclosed in nearly all consumer credit transactions, is designed to take into account all relevant factors and to provide a uniform measure for comparing the cost of various credit transactions. The APR is a measure of the cost of credit, expressed as a nominal yearly rate. It relates the amount and timing of value received by the consumer to the amount and timing of payments made. The disclosure of the APR is central to the uniform credit cost disclosure envisioned by the TILA. CFPB, April 2015, TILA 14. CFPB, Laws and Regulations TILA. The value of a closed-end credit APR must be disclosed as a single rate only, whether the loan has a single interest rate, a variable interest rate, a discounted variable interest rate, or graduated payments based on separate interest rates, step rates, and it must appear with the segregated disclosures. Segregated disclosures are grouped together and do not contain any information not directly related to the disclosures required under Section 1026.18. Since an APR measures the total cost of credit, including costs such as transaction charges or premiums for credit guarantee insurance, it is not an interest rate, as that term is generally used. APR calculations do not rely on definitions of interest in state law and often include charges, such as a commitment fee paid by the consumer, that are not viewed by some state usury statutes as interest. Conversely, an APR might not include a charge, such as a credit report fee in a real property transaction, which some state laws might view as interest for usury purposes. Furthermore, measuring the timing of value received and of payments made, which is essential if APR calculations are to be accurate, must be consistent with parameters under Regulation Z. The APR is often considered to be the charge expressed as a percentage. However, two loans could require the same finance charge and still have different APRs because of differing values of the amount financed or of payment schedules. For example, the APR is 12% on a loan with an amount financed of $5,000 and 36 equal monthly payments of $166.07 each. It is 13.26% on a loan with an amount financed of $4,500 and 35 equal monthly payments of $152.18. Each and final payment of $152.22. Both cases, the finance charge is $978.52. The APRs on these example loans are not the same because an APR does not only reflect the finance charge. It relates the amount and timing of value received by the consumer to the amount and timing of payments made. The APR is a function of the amount financed, which is not necessarily equivalent to the loan amount. For example, if the consumer must pay at closing a separate 1% loan origination fee prepaid finance charge on a $100,000 residential mortgage loan, the loan amount is $100,000, but the amount financed would be $100. 0,000, less the $1,000 loan fee, or $99,000. The finance charge, which is not necessarily equivalent to the total interest amount, interest, is not defined by Regulation Z, but rather is defined by state or other federal law. For example, if the consumer must pay a $25 credit report fee for an auto loan, the fee must be included in the finance charge. The finance charge in that case is the sum of the interest on the loan, i.e., interest generated by the application of a percentage rate against the loan amount, plus the $25 credit report fee. If the consumer must pay a $25 credit report fee for a home improvement loan secured by real property, the credit report fee must be excluded from the finance charge. The finance charge in that case would be only the interest on the loan. CFPB, April 2015, TILA 15. CFPB, Laws and Regulations TILA. The payment schedule, which does not necessarily include only principal and interest PI payments. For example, if the consumer borrows $2,500 for a vacation trip at 14% simple interest per annum and repays that amount with 25 equal monthly payments beginning 1 month from consummation of the transaction, the monthly PI payment will be $115.87 if all months are considered equal, and the amount financed would be $2,500. If the consumer's payments are increased by $2 a month to pay a non-financed $50 loan fee during the life of the loan, the amount financed would remain at $2,500. But the payment schedule would be increased to $117.87 a month. The finance charge would increase by $50, and there would be a corresponding increase in the APR. This would be the case whether or not state law defines the $50 loan fee as interest. If the loan above has 55 days to the first payment, and the consumer prepays interest at consummation $24.31 to cover the first 25 days. The amount financed would be $2,500, $24.31, or $2,475.69. Although the amount financed has been reduced to reflect the consumer's reduced use of available funds at consummation, the time interval during which the consumer has use of the $2,475.69, 55 days to the first payment, has not changed. Since the first payment period exceeds the limitations of the regulation's minor irregularities provisions, see $1,026.17 C4, it may not be treated as regular. In calculating the APR, the first payment period must not be reduced by 25 days, i.e., the first payment period may not be treated as 1 month. Financial institutions may, if permitted by state or other law, pre-compute interest by applying a rate against a loan balance using a simple interest, add-on, or some other method, and may earn interest using a simple interest accrual system. The rule of 78, if permitted by law or some other method. Unless financial institutions' internal interest earnings and accrual methods involve a simple interest rate based on a 360-day year that is applied over actual days, even that is important only for determining the accuracy of the payment schedule. It is not relevant in calculating an APR, since an APR is not an interest rate, as that term is commonly used under state or other law. Since the APR normally need not rely on the internal accrual systems of a bank, it always may be computed after the loan terms have been agreed upon, as long as it is disclosed before actual consummation of the transaction. Special requirements for calculating the finance charge and APR. proper calculation of the finance charge and APR are of primary importance. The regulation requires that the terms finance charge and annual percentage rate be disclosed more conspicuously than any other required disclosure, subject to limited exceptions. The finance charge and APR, more than any other disclosure, enable consumers to understand the cost of the credit and to comparison shop for credit. A creditor's failure to disclose those values accurately can result in significant monetary damages to the creditor, either from a class action lawsuit or from a regulatory agency's order to reimburse consumers for violations of law. If an APR or finance charge is disclosed incorrectly, the error is not in itself a violation of the regulation if CFPB, April 2015, TILA 16, CFPB. Laws and Regulations, TILA. The error resulted from a corresponding error in a calculation tool used in good faith by the financial institution. Upon discovery of the error, the financial institution promptly discontinues use of that calculation tool for disclosure purposes. The financial institution notifies the CFPB in writing of the error in the calculation tool. When a financial institution claims a calculation tool was used in good faith, the financial institution assumes a reasonable degree of responsibility for ensuring that the tool in question provides the accuracy required by the regulation. For example, the financial institution might verify the results obtained using the tool by comparing those results to the figures obtained by using another calculation tool. The financial institution might also verify that the tool, if it is designed to operate under the actuarial method, produces figures similar to those provided by the examples in Appendix J to the regulation. The calculation tool should be checked for accuracy before it is first used and periodically thereafter.